There is a quiet tension that can arise in ordinary transactions, especially when speed becomes the unspoken priority. Picture a retail counter where forms must be completed, identification reviewed, and background checks processed. The line grows longer. The clerk moves quickly. For someone who needs additional time, perhaps because reading takes longer than it once did, or hearing instructions requires repetition, that environment can create pressure that feels personal. Yet, from a legal standpoint, the situation is not governed by impatience or convenience. Federal disability law already sets the framework. The Americans with Disabilities Act recognizes age-related limitations, slower mobility, reduced vision, diminished hearing, or the need for extra time to process written information, as conditions that can trigger legal protection. When those factors are present, the interaction is no longer simply a matter of courtesy. It becomes a matter of compliance with federal standards. A retailer cannot lawfully rush a required federal form because others are waiting. They cannot deny a lawful purchase simply because clarification is requested. Even delays in background checks cannot be treated as inherently suspicious if they arise as part of the normal process. Keep that distinction in mind as we move forward. Patience in this context is not a favor. It is a requirement grounded in law. The practical impact of that principle becomes clearer through example. In one case described in the source material, a man in his early 70s in Arizona encountered resistance after taking additional time to complete paperwork. Rather than apologizing or escalating the situation, he calmly stated that he was requesting reasonable accommodation under federal disability law. That single reference to a legal standard shifted the tone of the exchange. The pressure eased, the transaction continued. The point is not confrontation, it is awareness. Many stores prioritize efficiency, but efficiency does not override statutory protections. If an older customer feels hurried or subtly discouraged during a firearm purchase, the law does not treat that as a trivial inconvenience. It treats it as a compliance issue. Pause here and consider how often rights go unused simply because no one names them. That theme repeats in other areas as well. For example, long-standing firearms training, such as hunter education completed decades ago, may still satisfy modern competency requirements in numerous states. The source notes that jurisdictions including Wisconsin, Virginia, Idaho, Arizona, and Oregon accept prior hunter education certificates as valid proof of training for concealed carry permits, often without expiration dates. Many seniors, unaware of this continuity, enroll in new classes that replicate material they already mastered. The legal structure in those states respects documented experience. Before paying for additional instruction, a simple inquiry to a state licensing office can clarify whether older credentials already meet present standards. Listening carefully for how older qualifications remain legally relevant can save both time and expense. Cost considerations surface again when examining concealed carry permit fees. It is commonly assumed that fees are fixed in uniform, but the source explains that several states reduce costs once applicants reach a certain age. Louisiana, for instance, charges lower rates for applicants 65 and older, including reduced fees for lifetime permits. Alabama has offered lifetime pistol permits at discounted rates beyond a specified age threshold. Texas lowers renewal fees for older residents. These policies reflect legislative judgments that seniors are often on fixed incomes and statistically less likely to misuse firearms. They also reduce administrative repetition, limiting renewals and background checks. Yet these reductions are not always prominently advertised. Online portals may display standard fees without emphasizing age-based adjustments. The result is predictable. Individuals who do not ask pay more than necessary. Take a moment to track the pattern emerging here. In each instance, the benefit exists in statute or policy, but it requires awareness to activate. The same dynamic appears in hunting regulations. Some states eliminate license requirements entirely for older residents. Florida allows residents 65 and older to use a standard driver's license in place of a separate hunting or fishing license for specified activities. Georgia employs a birth year cutoff. Those born before January 1, 1961 are exempt from certain hunter education requirements. Other states adopt comparable exemptions, often embedded deep within regulatory text. Lawmakers justified these distinctions on grounds similar to those behind fee reductions. Experience and long-term familiarity with firearms practices are taken into account. Before assuming that every posted requirement applies equally, reviewing the fine print of a state's wildlife regulations can reveal exemptions tied directly to age or birth year. Membership policies within gun rights organizations follow a comparable structure. According to the source, several major organizations quietly offer discounted rates for seniors, particularly for lifetime memberships. The benefits, publications, legal updates, training materials, insurance options, and retail discounts remain the same. Only the pricing shifts. Yet standard rates are typically listed first, and unless an applicant specifically inquires about senior pricing, the higher fee is applied. Over years of membership, that difference can accumulate significantly. At this stage, it may help to reflect on the broader legal logic. Age, in many contexts described here, does not diminish rights, but can alter the administrative framework surrounding them. That principle becomes especially important when addressing a persistent misconception that simply growing older can lead to automatic loss of firearm rights. Federal law does not revoke ownership rights based on age alone. Disqualification requires formal legal action, including a judicial determination of mental incompetence. A medical diagnosis, the use of medication, reliance on assistive devices, or even assistance with financial management does not independently remove constitutional protections. Guardianship arrangements in many states do not automatically terminate firearm rights unless a court specifically orders that outcome. The source emphasizes that many seniors voluntarily surrender firearms due to misunderstanding or implied pressure rather than legal necessity. Once relinquished, restoring those rights can be complicated and uncertain. Notice how the legal threshold centers on due process, a judge, a hearing, and a clear finding. Without that procedural foundation, age itself carries no disqualifying force. Another dimension of federal law affects retired law enforcement officers. Under the Law Enforcement Officer Safety Act, qualified retired officers who meet specified service and identification requirements may carry concealed firearms nationwide, irrespective of varying state permit systems. Eligibility generally depends on length of service or retirement due to service-related disability, possession of official photographic identification from the former agency, and annual firearms qualification. Some states have attempted to impose additional requirements, but federal courts have interpreted the statute as preempting conflicting state restrictions. The source notes that many retired officers remain unaware of this authority, assuming that retirement ends nationwide carry privileges. As you listen, consider how federal preemption operates. When Congress enacts a statute that clearly supersedes state law, state-level limitations yield to the federal framework. That structural principle shapes the reach of LEOSA. A related example of federal oversight involves a regulatory proposal affecting Social Security recipients. In 2017, a rule developed during the Obama administration would have allowed individuals with representative payees, those who receive assistance managing Social Security benefits, to be reported to the federal background check system as prohibited persons without individualized court findings of mental incompetence. Congress repealed the rule before full implementation. The repeal reinforced a procedural norm. Financial assistance does not equate to legal incapacity absent judicial determination. Here again, due process stands at the center. Policies that bypass hearings and explicit findings raise constitutional concerns, particularly when they affect fundamental rights. The lesson is not partisan, it is procedural. Rights removed without formal adjudication invite scrutiny. Finally, the legal treatment of recreational vehicles illustrates how classification can change rights in subtle but consequential ways. When an RV is parked, connected, and functioning as a residence, many states treat it similarly to a home for purposes of firearm storage and possession. In that stationary context, loaded firearms within the living area may be lawful under the same principles that apply to a fixed dwelling. However, once the vehicle is in motion, the legal category shifts. It becomes a vehicle subject to transportation laws, which may require firearms to be unloaded, secured, and inaccessible unless the individual holds a valid carry permit recognized by the jurisdiction. Crossing state lines compounds the complexity, as reciprocity rules differ. The same firearm that was lawful and accessible while parked